All right, today we are diving into a really fascinating and honestly kind of wild new legal strategy that's turning environmental law on its head. It's a story about a big Supreme Court decision, a law that's over 100 years old, and a statute that was originally made to take down the mob. Let's get into it.
I mean, it sounds like a trick question, doesn't it? How on earth could dumping some gunk into a puddle, something totally isolated, not connected to anything, get you charged with organized crime? Well, believe it or not, the answer is a surprising yes. And the story of how we got there is just incredible.
So, to really understand this legal puzzle, we've got to rewind a bit. It all starts with a huge decision from the Supreme Court that, well, created a massive problem for anyone trying to enforce environmental laws.
For the longest time, things were pretty clear. You had the Clean Water Act, the CWA, and it was the big gun for protecting our waterways. It cast a really wide net, covering pollution in basically all waters of the United States, and that was interpreted broadly to include all sorts of streams and wetlands. But then 2023 happened, and with it came the landmark case Socket versus the EPA. And let me tell you, this ruling was a seismic shift. It didn't just tweak the rules a little bit, it fundamentally tore up the map of what the federal government could actually protect.
And you can really see the difference here. Before the Sackett case, you had that broad protection we talked about. After Sackett, the Clean Water Act was suddenly limited only to waters with a continuous surface connection to bigger navigable bodies of water. So think about it. If a wetland didn't have a constant, year-round, visible link to a river, poof, it was basically on its own.
The immediate result was what lawyers love to call a jurisdictional gap. And what that really means is that overnight, countless streams that only flow when it rains and all those isolated wetlands, they just lost their federal protection from polluters. And that was a huge problem. But, when the law closes one door, clever lawyers will always try to find another one to open. And in this case, prosecutors found a really surprising workaround by dusting off some much older and pretty unexpected legal tools. Okay, first up is the Refuse Act of 1899. Yeah, you heard that right, 1899. This law is from the horse and buggy days, and it says you can't dump refuse into navigable waters or, and this is the important part, into any tributary where that junk could get washed downstream. That one word, tributary, is everything. Now, the second piece of this puzzle is the RICO Act from 1970. This is the famous law, right? The one they used to take down mob bosses. It was specifically designed to fight organized crime by going after the entire criminal enterprise and its whole pattern of illegal activity. So, what does this have to do with puddles? Well, starting in 2025, prosecutors got really creative. They figured out they could actually weave these two totally separate laws together to create a brand new enforcement tool, one that could maybe, just maybe, close that giant gap the Sackett decision had created. Let's look at exactly how they pulled it off. Okay, this is where it gets really, really interesting. Let's break down the mechanics of what everyone is now calling the RICO upgrade. So the core theory is this: the very act of illegally dumping something can, in a strange legal way, transform an unprotected puddle into a federally regulated waterway. It's a fascinating idea they're calling the navigable in fact puddle theory. So here's how it works, step by step. First, a company illegally dumps waste into some isolated puddle to save a buck, a puddle that's not covered by the new Clean Water Act rules. Step 2, the pile of junk itself creates a channel, a man-made pathway for rainwater to wash pollutants downstream toward a real river. Step 3, under that old Refuse Act, that man-made channel now makes the puddle a tributary, and boom, that's a violation. The final step is the most mind-bending part. The crime itself is what creates the federal jurisdiction. So, how do you upgrade this to racketeering? This is where it all comes together. The company itself? That's your criminal enterprise. The money they saved by dumping illegally? That's treated as criminal income. And because they can charge a Refuse Act violation for every single day of dumping, you've got a pattern of racketeering activity. Then you tack on charges for faking compliance records and sending them through email, and suddenly you have a full-blown federal RICO case. Now, this legal creativity isn't just an academic exercise. The consequences of this upgrade are enormous. It transforms what was a relatively minor offense into a major federal crime with incredibly severe penalties. See, on its own, a violation of that old Refuse Act is just a misdemeanor. The max fine is about $25,000 a day. Now, that's a lot of money, for sure, but for a massive corporation, that could just be the cost of doing business.
But the second you bring RICO into the mix, the game completely changes. This isn't just about the Refuse Act anymore. It's about racketeering. And that unlocks a much, much more powerful way to calculate the fines. And that tool is the Alternative Fines Act, which lets the fine be set at twice the gross pecuniary gain. In simple terms, whatever amount of money the company saved by breaking the law, the fine can be double that amount. All of a sudden, we're not talking about thousands of dollars anymore. We're talking about potentially millions. And it's not just about the money, not by a long shot. A RICO conviction brings way harsher sentencing guidelines. As you can see, judges can add levels for things like repetitive dumping or not having a permit. And if the pollution creates a substantial risk of death or serious injury, that's a massive 11-level jump. That means serious prison time is absolutely on the table. So the end result of all this legal maneuvering is something people are now calling a shadow jurisdiction. By stitching together an old maritime law with an anti-mob statute, the federal government has found a way to reestablish its authority over the very same waters that the Supreme Court's socket decisions seem to place completely out of its reach. Which leaves us with this huge, fascinating question, right? Is this a brilliant, necessary legal fix to protect our environment when the Clean Water Act has been weakened? Or is it a dangerous case of federal overreach, stretching these old laws far beyond anything they were ever intended to do? That's something the courts and all of us are going to have to think about. Thanks for tuning in.